So I had somebody ask me, what what nation do we pledge our allegiance to, right? And I hope that this will provide some clarity for people seeking the answer. Again, don't take my word for it. Go do your own research on the subject matter. But the Internal Revenue Code relies on the statutory definition of the United States, which means federal territory. The term citizen is nowhere defined within the Internal Revenue Code and is defined twice within the implementing regulations at Title 26 CFR subsection 1.1-1 and Title 26 CFR subsection 31.3121E-1. Below is the following of these two definitions. Title 26 CFR subsection 1.1-1 income tax on individuals. C. Who is a citizen? Every person born or naturalized in the United States and subject to its jurisdiction. Now, I'm going to point out the little Jesuitical tricks they use. And I did this once to a judge after somebody had bestowed the knowledge on me. They said, Derek, when you go in there, buddy, check it out. Just see if we're full of shit. When they go in there and they ask you if you are Derek Gonzalez, just do one thing for us. Instead of saying that you are, say that you say that you were known as Derek Gonzalez. And so I went into the court and they said, are you Derek Gonzalez? I said, no, I'm here as Derek Gonzalez. They said, no, you either are or you are not. And I said, again, I'm here as Derek Gonzalez. No, I'm going to say this one more time. You either are or you are not Derek Gonzalez. Are you or are you not? And again, I said, I am here as Derek Gonzalez. That one little word changes everything, okay? And proof of that is Bill Clinton during his impeachment says, well, it all depends on the word is and what is means and how is defined, right? So just that one little word, one of my mentors helped show me, one, the power of words, and two, that if you are Derek Gonzalez, then you are proclaiming to be something. If you're coming as Derek Gonzalez, you are not Derek Gonzalez, but you are as Derek Gonzalez, which are two distinct and different things, okay? So every person born or naturalized in the United States and subject to its jurisdiction is a citizen. For other rules governing the acquisition of citizenship, see Chapter 1 and 2 of Title 3 of the Immigration and Nationality Act, Title 8 USC subsection 1401 through 1459. For rules governing loss of citizenship, see sections 349 to 357. Exclusive of such act, Title 8 USC subsection 1481 through 1489, Shindir versus Rusk, 377 U.S. 163, and this case was in 1964, and Rev Rule 70-506, C.B. 1970-2, for rules pertaining to persons who are nationals but not citizens at birth, ergo, a person born in American Samoa, see Section 308 of such act, Title 8 USC subsection 1408, for special rules applicable to certain expatriates who have lost citizenship with a principal purpose of avoiding certain taxes, see Section 877. A foreigner who has filed his declaration of intentions of becoming a citizen, but who has not yet been admitted to citizenship by a final order of a naturalization court, is an alien. Okay, now we're going to go further on into this, because remember, I told you, pay particular attention. These are the little Jesuitical tricks. It's very ingenious to just change one word, which it changes the entire context of the application of the sentence, okay? Notice the term born or naturalized in the United States and subject to its jurisdiction, which means the exclusive legislative jurisdiction of the federal government within the District of Columbia and its territories and possessions under Article 1, Section 8, Clause 17 of the Constitution and Title 48 of the U.S. Code. If they meant to include states of the Union, they would have used their, T-H-E-I-R, jurisdiction or the jurisdiction as used in Section 1 of the 14th Amendment instead of its jurisdiction. It is those little minute changes within the context of the sentence structure that alters the entire meaning of what they are articulating to you in the verbiage or in the literature that is presented, okay? The 13th Amendment to the Constitution prohibiting slavery and involuntary servitude within the United States or in any place subject to their jurisdiction is also significant as showing that there may be places within the jurisdiction of the United States that are no part of the Union. Let me say that again. Subject to their, T-H-E-I-R, jurisdiction is also significant as showing that there may be places within the jurisdiction of the United States that are no part of the Union. To say that the phraseology of this amendment was due to the fact that it was intended to prohibit slavery in the seceded states under a possible interpretation that those states were no longer a part of the Union is to confess the very point in issue, since it involves an admission that if these states were not a part of the Union, they were still subject to the jurisdiction of the United States. Upon the other hand, the 14th Amendment, upon the subject of citizenship, declares only that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Here there is a limitation to persons born or naturalized in the United States, which is not extended to persons born in any place, subject to their, T-H-E-I-R, jurisdiction. Downs versus Bidwell, 182 U.S. 244, 1901. The above definition of citizen applying exclusively to the Internal Revenue Code reveals that it depends on Title 8 U.S.C. subsection 1401, which means a human being and not artificial born anywhere in the country, but domiciled in the federal United States federal zone, Title 28, 3002, 15A, B, or C, a federal corporation, the federal territories, federal enclaves, Guam, Samoa, the Outer Minor Mariana Islands, which includes territories or possessions and excludes states of the Union. These people possess a special non-constitutional class of citizenship that is not covered by the 14th Amendment or any other part of the Constitution. People born in states of the Union are technically not statutory, national, and citizens of the United States. Okay, so they do not belong to Title 28, 3002, 15A, the District of Criminals, the District of Columbia. Okay, they are not part of any territory, okay, or possession thereof under Title 8 U.S.C. subsection 1401, but instead are statutorily defined, I should say, rather, as non-resident non-persons. Okay, so if you're a non-resident non-person as statutorily defined, you do not belong to Title 28, 3002, 15A. You owe no allegiance to that corporation of criminals with a legislatively but not constitutionally foreign domicile under Title 8 U.S.C. subsection 1101 A21. The term national is defined in Title 8 USC subsection 1101A21 as follows. Now pay attention. Title 8 USC subsection 1101 definitions for the purpose of citizenship. A, as used in this chapter, 21. The term national means a person owing permanent allegiance to a state. Period. To a state. Okay? In the case of nationals who are also statutorily recognized as non-residents, non-persons, under Title 8 USC subsection 1101A21, these are people who owe their permanent allegiance to the Confederation of States in the Union called the United States of America that are constitutionally protected. So I hope that answers your question. And not the United States, which is the government and legal person they created to preside only over community property of State of the Union and foreign affairs, but not internal affairs within the states. The definition of citizen of the United States, found in Title 26 CFR subsection 31.3121E1, corroborates the above conclusions, keeping in mind that United States within that definition means the federal zone instead of the states of the Union. Remember, United States, or United States of America, in the Constitution means the state of the Union, while United States in federal statutes means the federal zone only and excludes states of the Union. Title 26 CFR subsection 31.3121E1, state, United States, and citizens. E, the term citizen of the United States includes, so if it's including, then anything that it doesn't include in this definition, it naturally excludes. Includes a citizen of the Commonwealth of Puerto Rico or the Virgin Islands, and effective January 1st, 1961, a citizen of Guam or American Samoan. Puerto Rico, the Virgin Islands, Guam, and American Samoan are all U.S. territories and federal states that are within the federal zone. They are not states under the Internal Revenue Code. The proper subject of Internal Revenue Code, subtitle A, are only the people who are born in these federal states or territories. And these people are the only people who are in fact citizens and nationals of the United States, Title 28, 3002, 15A, under Title 8 USC subsection 1401, and under Title 26 CFR subsection 1.1-1C. The basis of citizenship in the United States is the English doctrine under which nationality meant birth within an allegiance of the king. The U.S. Supreme Court helped explain this concept precisely in the case of U.S. versus Wong Kim Ark 169 U.S. 649 898, wherein, upon the Revolution, no other change took place in the law of Northern Carolina than was consequent upon the transition from a colony dependent on an European king to a free and sovereign 169 U.S. 649 664 state, a sovereign state. Okay, British subjects in North Carolina became North Carolina freemen, and all free persons born within the state are born citizens of the state. The term citizens, as understood in our law, is precisely analogous to the term subject in the common law, and the change of phrase has entirely resulted from the change of government. The sovereignty has been transferred from the man to the collective body of the people, and he who before was a subject of the king is now a citizen of the state. State versus Manual, 1838, 4 DEV, period, ampersand sign B, 2024-26, U.S. versus Wong Kim Ark, 169 U.S., 649, 1898 was when the case was held. In our country, following the victorious revolution of 1776, the king was therefore replaced by the people, who are collectively and individually the sovereigns within our republican, not democracy, republican form of government. The group of the people within whatever body politic one is referring to, who live within the territorial limits of that body politic, are the thing that you claim allegiance to when you claim nationality to any one of the following three distinctive political bodies. Okay, now there are three distinctive political bodies. 1, a state that composes the Union of States. 2, the country, United States, as defined in our Constitution. Okay, and 3, the other political body politic that you could subject yourself to, which is highly unadvisable. The municipal government of the federal zone called the District of Columbia, which was chartered as a federal corporation under 16 Stat 419 subsection 1 and Title 28 USC subsection 3002 15A, B, and C. All right, where it clearly articulates that by federal definition, it constitutes as a federal corporation. Okay? Now, with that said, you have choices. You have a choice of whether you're going to be a member of the state of the Union of States, the country, United States, as defined in our Constitution, or you can go with the latter, which by default, this is where you fall in at the age of 18. At the age of 18 and prior to the age of 18, you are presumed and assumed to belong to the municipal government of the federal zone called the District of Criminals, which was chartered as a federal corporation under 16 Stat 419 subsection 1 and Title 28 USC subsection 3002 15A, which means that you are perceived to be a U.S. citizen subject to civil statutory provisions. I don't even like calling them law. They're more private policy, okay, for their corporate construct, okay? Each of the three above political bodies have citizens. Okay, it's important, but really number 3 doesn't have citizens. It has subjects. It has volunteer slaves who are distinctively their own. When you claim to be a citizen of any one of the three, you aren't claiming allegiance to the government of that. You aren't claiming allegiance to the government of that body politic, but to the people, the sovereigns that the government serves. If that government is rebellious to the will of the people and is outside the boundaries of the Constitution that defines its authority so that it become a de facto government rather than the original de jure government it was intended to be, then your allegiance to the people must be superior to that of the government that serves the people. In the words of Jesus himself in John 15:20, remember the word that I said to you, a servant is not greater than his master. John 15:20, the master or sovereign in this case is the people who have expressed their sovereign will through a written and unchangeable constitution. The glory of our American system of government is that it was created by a written constitution which protects the people against the exercise of arbitrary, unlimited power and the limits of which instrument may not be passed by the government it created, or by any branch of it, or even by the people who ordained it, except by amendment or change of its provisions. Downs versus Bidwell, 182 U.S. 244, 21 S. CT 770, 1901. This is crucial. This is a crucial distinction you must understand in order to fully comprehend the foundation of our Republican system of government. Let's look at the definition of citizen according to the U.S. Supreme Court in order to clarify the point we have made so far on what it means to be a citizen of our glorious republic. There cannot be a nation without a people. The very idea of a political community, such as a nation is, implies an 88 U.S. 162, 166 association of persons for the promotion of their general welfare, which is strikingly resembles the preamble to the Constitution, right? Each one of the persons associated becomes a member of the nation formed by the association. He owes its allegiance and is entitled to its protection. Notice how it doesn't say that you owe a tax in order for protection. It says you simply owe an allegiance and is entitled to its protection. Allegiance and protection are, in this connection, reciprocal obligations. The one is a compensation for the other. Allegiance for protection and protection for allegiance. For convenience, it has been founded necessary to give a name to this membership. The object is to designate by a title the person and the relation he bears to the nation. For this purpose, the words subject, inhabitant, and citizen have been used, and the choice between them is sometimes made to depend upon the form of the government. Citizen is now more commonly employed, however, and as it has been considered better suited to the description of one living under a republican government, it was adopted by nearly all the states upon their separation from Great Britain, and was afterwards adopted in the Articles of Confederation and in the Constitution of the United States. When used in this sense, it is understood as conveying the idea of membership of a nation and nothing more. To determine then who were citizens of the United States before the adoption of the amendment, it is necessary to ascertain what person originally associated themselves together to form the nation, and what were afterwards admitted to membership. Looking at the Constitution itself, we find that it was ordained and established by the people of the United States. And then going further back, we find that these were the people of the several states that had before dissolved the political bands which connected them with Great Britain, and assumed a separate and equal station among the powers of the earth, and that had by Articles of Confederation and Perpetual Union in which they took the name of the United States of America, entered into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all forces offered to or attack made upon them or any of them on account of religion, sovereignty, trade, or any other pretense whatever. Whoever then was one of the people of either of these states when the Constitution of the United States was adopted became ipso facto a citizen, a member of the nation created by its adoption. He was one of the persons associating together to form the nation, and was consequently one of its original citizens. As to this, there has never been a doubt. Disputes have arisen as to whether or not certain persons or certain classes of persons were part of the people at the time, but never as to their citizenship if they were. Minor versus Happersett, 88 U.S. 162, 1874, emphasis added. The thing to focus on is, in the above, is the phrase, he owes allegiance and is entitled to its protection. People domiciled in states of the Union have dual allegiance and dual nationality. They owe allegiance to two governments, not one. So they are dual nationals. They are dual nationals because the state of the Union are independent nations. Dual citizenship. Citizenship in two different countries, status of citizenship of the United States who reside within a state, i.e. person who are born or naturalized in the United States are citizens of the United States and the states wherein they reside. Black's Law Dictionary, 6th edition, page 498. Likewise, those people who live in a federal state, like Puerto Rico, also owe dual allegiance. One to the District of Columbia, which is their municipal government and which possesses the policy powers that protect them, and the other allegiance to the government of the United States of America, which is the general government for the whole country. As we said before, Congress wears two hats and operates in two capacities or jurisdictions simultaneously, each of which covers a different and mutually exclusive geographical area. As the municipal government of the District of Columbia and all U.S. territories, all acts of Congress or federal statutes passed in their capacity are referred to as private international law. Private international law. This political community is called the national government. Okay. Number 2. As general government for the states of the Union, all acts of Congress of federal statutes passed in the capacity are called public international law. This political community is called the federal government. Each of the two capacities above, the different types of citizens within it, each of the two capacities above has different types of citizens within it, and each is unique and separate. Body politic. Most laws that Congress writes pertain to the first jurisdiction above only. Okay? Before is a summary of these two classes of citizens. Jurisdiction. Municipal government of the District of Columbia and all U.S. territories, also called the national government. Land area, the federal zone, the 10 square miles of the District of Columbia and its territories and federal enclaves, okay? States. And the name of the citizen is a statutory citizen or citizen and national of the United States as defined in Title 8 U.S.C. subsection 1401. Number 2, general government for the states of the Union, also called the federal government, United States of America, the 50 Union states, okay, and constitutional citizens or nationals but not citizens of the United States as defined in Title 8 U.S.C. subsection 1101 A21. The U.S. Supreme Court recognizes the above two separate political and legislative jurisdictions and their respective separate types of citizens when it held the following. The first session of the 14th Article, 14th Amendment, to which our attention is more specifically invited, opens with a definition of citizenship. Not only citizenship of the United States, which is the federal constitutionally created United States of America, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempts been made to define it by an act of Congress. It had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said by eminent judges that no man was a citizen of the United States except as he was a citizen of one of the states composing the Union. So in order to fall underneath the federal constitution, the organic constitution for the United States of America, one must be a state national, a citizen of a state composing of the Union. Real cut and dry, fucking simple as can be, people. All right? I have very limited internet where I'm at. Otherwise, I would pull up the Government Styles Manual, the GPO Manual of 2016, page 95, chapter 5, 24.3, 24.4, possibly 24.5. If you'll pull up that in the internet of things and you will look up the Government Styles Manual, it clearly articulates that if you are a member of the Union of States, then you have a different way of defining yourself. For example, Arizona is an Arizonan. an Indiana man is recognized as a Hoosier, which I find really funny, but that's what it is. So those, therefore, who have been born and reside always in the District of Columbia or in the territories, though within the United States, were not citizens thereof. Slaughterhouse Case 83 U.S. 16 Wall 36 21 L period ED period 394 1873. I hope that helps you understand and comprehend the question that you were asking. I'll go a little further. Federal statutes and acts of Congress do not and cannot prescribe the statutory citizenship status of man born in and domiciled in states of the Union and outside of the exclusive or general legislative jurisdiction of Congress. Title 8 U.S.C. subsection 1408(2) comes the closest to defining their citizenship status, but even that definition doesn't address most persons born in states of the Union, neither of whose parents even reside in the federal zone. No federal statute or acts of Congress directly can or does prescribe the citizenship status of the people born in states of the Union, because state law and not federal law prescribes their status under the law of nations. The reason is because no governments may write civil laws that apply outside of their subject matter or exclusive territorial jurisdiction. And states of the Union are statutorily but not constitutionally foreign to the United States government for the purpose of policy powers and legislative jurisdiction. Here is confirmation of that fact, which the geographical definition within the federal also confirm. Judge Story, one of my favorite judges, Joseph Story, in his treatise on the conflict of laws, lays down as a basis upon which all reasoning on the law of committee must necessarily rest the following maxim. First, that every nation possesses an exclusive sovereignty and jurisdiction within its own territory. And secondly, that no state or nation can by its laws directly affect or bind property out of its own territory or bind persons not resident therein, whether they are natural-born subjects or others. The learned judge then adds, from these two maxims or propositions, there follows a third, and that is that whatever force and obligation the laws of one country have in another depends solely upon the laws and municipal regulations of that matter. That is to say, upon its own proper jurisdiction and polity, and upon its own express or tacit consent. Story on Conflict of Laws, subsection 23. Baltimore and Ohio Railroad Code versus Chambers, 73 Ohio, ST 1676, N period E period 91, 11 L period R period A period, N period S period, 1012. This was decided in 1905. Congress is given the authority under the Constitution, Article 1, Section 8, Clause 4, to write an uniform rule of naturalization, and they have done this in Title 8 of the U.S. Code, called the Aliens and Nationality, but they were never given any authority under the Constitution to prescribe laws for the states of the Union relating to citizenship by birth, rather than naturalization. That subject is, and always has been, under the exclusive jurisdiction of the state of the Union. Naturalization is only one of two ways by which a person can acquire citizenship, and Congress has jurisdiction only over one of the two ways of acquiring citizenship.